Mr. Johnson, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to the theft of a motor vehicle at a residence in Harris County, Texas. The officer made contact with the complainant, who advised that his truck was stolen off the property at 12:42 p.m., and the complainant showed officers clear footage of the theft, where the officer observed 3 white males exiting a motor vehicle, one suspect going under the hood of the complainant's vehicle and getting in the passenger seat, and another suspect drive the motor vehicle off the property. The officer got the suspect's motor vehicle's license plates, ran that license plate through Lens, and got an address. When the officer arrived at that address, he observed the motor vehicle used to commit the theft in the driveway and knocked on the door and met with all parties inside the home. All subjects matched the subjects on surveillance, and the defendant had the same clothes as in the footage. The second defendant admitted to driving the motor vehicle and showed where he dumped the vehicle, and the complainant's vehicle was recovered. The first defendant, Mr. Johnson, admitted to helping the second defendant steal the motor vehicle.
So you're telling me that they allegedly stole a car?
Yes, Judge.
He's charged with a misdemeanor theft, Class B.
Yes, Judge.
What is the value of the car?
According to the DIMS, the complainant advised the value was $600.
Does he make a statement that he knows the car stolen?
He makes a statement that he admitted to help steal the vehicle.
Okay. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with your case. We do have co-defendants in this case, do we not?
Yes, Judge.
I'm ordering you as a condition of your bond not to have any contact with the co-defendants in this case and not to have any contact with the complaining witness in this case. You pick up a new case, you endanger my community, I'm going to revoke your bond, I'm going to put you in jail, and I'm going to make it extremely high. Do you understand, Mr. Johnson?
I do understand.
What do you do for a living, sir? How do you support yourself?
Sir,
How do you support yourself?
I'm trying to get disability right now, sir.
All right, I'll help you fill out an application. Do you mind giving me an application? Do not leave until you sign our bond conditions, otherwise
Yes,
I will
sir.
issue a warrant for your arrest. I'm going to give you an application. I'm going to have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
And
Mr. Shagoya, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 18th, 2025, at approximately 4:30 a.m., the officer observed the vehicle fail to stop at a red light at the East Texas Freeway on Harris County, Texas. The vehicle would have struck the officer's patrol vehicle had the officer not come to a stop. A traffic stop was then initiated, and the vehicle continued to drive 0.5 miles before stopping. The officer made contact with the defendant, the driver and sole occupant, and observed an odor of alcoholic beverage, glossy eyes, and slurred speech. Standard field sobriety tests were conducted, HGN 6 out of 6. The officer did not conduct walk and turn and one-leg stand due to safety concerns and the nearby sidewalk not being level. The officer observed a Glock 9mm in plain view from the front passenger window located on the passenger floorboard near the center console, and a PC search was then conducted. A second loaded firearm was found in the center console, and the defendant was then read the DIC and refused. A blood search warrant was signed and executed.
Mr. Shagoya, I'm going to find that there's probable cause to go forward with your case. Have you run his license?
It is eligible, Your Honor.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand?
Sure.
I'm also ordering you not to be in possession of any weapons as well, sir. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he can't get a hold of you, or you've taken off, or you pick up a new case, I will revoke your bond. Have you looked to see if he has any prior DWIs, Alex? Please.
He has one moment, Your Honor. No priors.
Okay. All right. So for now, I'll have you sign a reset with Victoria. We'll get you with Felicia for your bond conditions, and after that, you'll be free to go, sir.
Thank you, Judge.
Thanks, guys.
Excuse me.
Please. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated she and the defendant have been in a dating relationship for 11 months. The complainant then stated the defendant continuously assaulting her, and she showed surveillance video of the incident to the officers. The officers observed the defendant grab the complainant by the hair and strike her several times in the face with a boxing glove. The officer also observed the defendant get on top of the complainant and pin her down, striking her in the face, and the complainant advised she felt pain from all the strikes. The officer observed the complainant to have visible abrasions on her left shoulder and bicep, along with redness on her face.
He just had an assault that was dismissed in October of this past year.
Yes,
Is this the same complaining
Same
witness?
complainant.
Okay. Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever. I'm issuing what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rubio as a protected individual. You're not to commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. Is this a stalking statute? You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Melbourne Street place. Do you understand?
Yes, sir.
I want you to understand that I'm going to protect every single person in this county by all means necessary. You endanger my public, it's not going to go well for you. Felicia, I want to make sure that he's not consuming alcohol or drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, make your bond very high. Do you understand?
Yep, Judge, the milk was signed last Friday. It was signed by a magistrate court. On the 18th, or last Saturday, actually. You scroll all the way to the bottom.
Okay. So it looks like a protective order has been issued. I would get to know it because if you violate this protective order, the state can and will file a violation of protective order. That is the capital murder of misdemeanors. Do you understand, sir?
Judge, the magistrate also did order a GPS device that was
Yep.
installed prior.
I'm okay with that.
I have it on, sir.
Did you want do you need a lawyer, sir? Okay, so you don't want a court-appointed lawyer then? Okay, I'm gonna have you sign a reset. After that, we'll get with Felicia for your bond condition. After that, you're free to go.
Okay, pause right there. Johnson admits to helping steal the vehicle. Game over, right? But here's the twist, the car is only worth $600. That means this is a misdemeanor, not a felony. In Texas, anything under $2,500 falls into that category. Does that change how serious this feels to you? Should the value affect the charge, or should the act itself carry the weight? Now, a boxing glove comes into play. That's not just an assault, it feels theatrical and terrifying.
License plate. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The officer observed the firearm in the passenger side door, and the officer asked the defendant to step out. The officer observed a firearm in the driver's side door, and both firearms were unholstered. The officer asked the defendant for consent to search the vehicle, and the defendant agreed. The officer searched the vehicle within hand's reach of the defendant, and the officer observed a Ziploc bag in the glove compartment with a $20 bill and what appeared to be small baggies with a white powdery substance inside, believed to be cocaine based on training experience. The weight was 3.77 grams.
Okay, sir, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to be in possession of any weapons. Do not pick up any new cases. Otherwise, I'm going to put you in jail. I don't know what your immigration status is, but if you go to jail and you spend any kind of time there, immigration, and you're not here with proper documentation, immigration will put a detainer on you. You will be stuck like Chuck in there until this case is over with and then shipped off to immigration. So beware what you do. I don't know what your status is, but if you're not here with permission, be good. You have a lawyer because you have one that will waive your appearance, but it is your responsibility to stay in touch with him. You pick up a new case, you endanger my community. It's not going to go well for you. Do you understand?
Yes,
We'll have you sign in recess. We will have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then after that, you'll be free to go. Thank you.
Thank you, Your Honor.
thank you for this.
You were charged with tampering with a government record with intent to make it genuine. Is that right?
I'm sorry. Say it one more time, Judge. I missed what you said.
You're charged with tampering with a government record. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 16th, 2025, the officer observed the defendant's vehicle with a paper license plate on North Freeway, East Service Road. The officer ran the license plate, and the license plate came back with no record. The officer observed the license plate was a copy and did not have required security features. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle. The defendant stated he received the license plate from the person who sold him the truck, that he receives a new license plate whenever he makes payments, and that he thought that was legal. The defendant stated he did not have insurance on the vehicle, and the officer ran the VIN and discovered the motor vehicle to be salvaged. The officer also found the vehicle has never been registered and had never had a state inspection. The defendant provided a dealer tag receipt for the license plate, listing him as a purchaser.
So he tried to purchase in good faith, Judge. He just, I don't see how there's any criminal intent.
But he's making payments and he gets a new license plate every time he gets a payment.
That's what the officer says he was saying.
Well, right, but I mean.
Right.
Marcos, I see what you're saying because he's charged with tampering, right? To tamper, you must. I know, let's pull the code.
Right.
Because I mean, do you have to make a willing,
But you negligently or recklessly.
an alteration, so to speak, you know? Let's see. $37.10. Bless you. No, that's. Oh.
Knowingly makes a false entry in the false alteration of a government record.
A person commits, if he knowingly makes a false entry in or false alteration of a government record, makes, presents, or uses any record, document, or thing with knowledge of its falsity with intent that it be taken as a genuine government record.
Your Honor,
I think that is what they're probably relying on in this case.
if I may, as the information alleges, it's subsection 6 where it possesses a governmental record with knowledge that it was obtained unlawfully. So,
Well, he doesn't know it was intended lawfully, even from.
Well, hold on. That's your burden, right?
yes, Judge, and in this case, we would show that reasonable certainty by his obtaining it every time he makes a new purchase and obtaining it from the person who obtained the vehicle rather than from the government. So it would be through that.
When I go buy a new car, though, they give me a tag. You know what I mean? So at some point, yes, you're supposed to get something like a license plate from, I guess, a state, from the state authority, right? They give you the license plate, but here,
They give you the paper plate, and you assume that they're going to do all the paperwork behind the scenes. They send it to the government, to the state agency. Then the state agency sends you the metal plates.
if this had been like maybe a month or two that he'd purchased it, perhaps. But if we're talking that he's had this car for like a year, then I don't think that's reasonable. I don't think that's a reasonable argument to make. So,
And I don't know how long.
and this car purchase,
Let me see, Your Honor. So the only thing in regard to the status of the vehicle is the officer only found that it was a salvaged vehicle, and he lists a date of loss as June or May 29th, 2020. So I don't know if that's when the defendant obtained it or that's just when
No,
it was
that's just when it was salvaged at
Yeah,
that
so
time.
that's
So
the
at that
only-
point, you can't even drive the car because it's salvaged, right?
Right, and
It's a
that's
salvage
the
title,
only
but
date that the officer provides. So, and, so with the information we
you have a
have,
copy of the tag?
let me see. So the buyer's tag lists an expiration date of February 5th, 2025 and lists the vehicle of the 2007 Chevrolet and it doesn't
Is
list.
this, it should say like a date of purchase, right? Why don't we do this? Look,
So it says it expired February 5th, and this happened on January 16th, and I just asked him when he bought it. He said it was about a month and a half ago. And I said, how many
let's do this. Show me. Let me give you more time. Let me just do a little bit more diligence.
Okay.
All right. We'll come back, but let me burn through all this because I didn't think it was going to take this much time, but we'll revisit. Okay.
Yes, yes.
Don't worry.
So, Mr. Montalongo, you're charged with two cases. You're charged with assault of a family member. You're also charged with terroristic threat. Both of those, you're facing up to a year in jail and or a $4,000 fine. I'm going to tell you now, you take off on me again, I'm going to make your bond so high you'll have hair falling out. Do you understand? As it stands now, your case is 1,289 days old on one. The other one is around another 2 years old as well. I'm assuming probable cause has been found already.
I would like to take up probable cause, Your Honor, on the terroristic threat one, if we can.
Okay.
Okay, go for it.
Yes, Judge. On February 28th, 2023, the officer responded to a terroristic threat and the complainant stated she is of the defendant and that prior to the day of the call, the defendant had been sending her threatening messages to her phone. The defendant sent a text saying, I hope you take a punch to the fucking face. I'm gonna break your fucking face with my fist, bitch. I want to hear your bones break. The complainant stated the defendant has been verbally abusing her and has a history of assaulting their father.
Your Honor, I believe the key element they're missing in this probable cause for the terroristic threat is the imminency. There's nothing showing that this is imminent, it's about to happen, or is going to happen, or some future event.
I mean, I'm going to.
I'm going to, it can be very vague, Your Honor. We don't know how long that's going to be. If it's like, hey, I'm coming over right now, or if he said that in person. I think the case law is pretty clear on the imminency on that. For example, like,
You're telling me there's case law that says I'm going to is not sufficient?
I have to look at the specific words of I'm going to, but it references a future event. So if it's in reference to a future event, it's not imminent. Therefore, it doesn't meet the requirement.
State response?
So what we have is that they had an argument the previous night and that the morning of the incident, that's when he sent the text saying, I'm gonna break your face with my fist. So that would go towards, I doesn't really address the imminent issue, but it does address a future threat.
Montalongo.
Your Honor, I would agree with where you were going, the I'm going to, and just the overall tone of the message is implying imminent and will put a reasonable person in fear.
I think so as well. Mr. Montalongo, I'm going to find that there's probable cause to go forward with your case. I'm now issuing a magistrate's order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot communicate with this person in any manner. Phone calls, text messages, any way. You're not to threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If I find that you violate this court order, I'm just going to put you in jail. Got to understand, I'm going to protect my public at all costs. I don't care who you are, what color, whatever. Do you understand? Now, I'm not waiving his appearance because the cases are super old. We got to figure out where we're going. So I'm going to give you guys one setting to figure out where we're going to go. Is discovery complete on both of these cases?
It appears that
Think about it. When domestic violence involves this level of aggression caught on surveillance, judges tend to act swiftly. That magistrate's order is no joke. It's basically a legal force field. Judge Fleischer makes it crystal clear, if you endanger the public, you're done. Here's where things get legally dicey. What does imminent threat really mean in court? Saying, I'm going to break your face. Does that sound like a direct attack or just heated words? The defense is poking at that legal gray area. But Judge Fleischer cites reasonableness. If it walks like a threat and texts like a threat, it probably is one. Was this enough to trigger the protective order?
At a residence in Harris County, Texas, who stated the defendant came to the cul-de-sac on a dirt bike, began revving the engine, which got the complainant's attention, and the complainants began recording the incident on their cell phone. The officers reviewed a video from the cell phone showing the defendant sitting on a dirt bike, continuously revving the engines, and the complainants made contact with the defendant, and the verbal argument began. The defendant made the comment, "It's y'all asses, I know where you live, I got y'all," and the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant's residence is only 0.7 miles from the complainant's residence.
Judge, I think the facts are going to show this stems from a confrontation that the neighbors had with his children, and that there's more context to the alleged threat that explains that. However, my understanding is.
So are they next door neighbors?
No, they
So-
live in the same general neighborhood, but there's already a pretrial bond condition of no contact.
Got it.
And I've explained to Mr. Schreiber that staying away from them is good.
Just really, that's all we're asking you to do. You know, you've got a great lawyer. Listen to him. He'll take care of you. I am going to find that there's probable cause to go forward with the case. Just don't have any weapons, don't have any contact, and all will be well. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Downey, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you've taken off, I'm going to issue a warrant for your arrest. Just don't pick up any new cases, okay? We'll have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Thanks, guys. Good morning, Mr. Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have
Judge.
the right to have an attorney present. If you're not afforded, one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no-caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100 plus times from a no-caller ID. The defendant spoke to the officer and admitted to calling the complainant 100 plus times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works. No weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just, life's way too short. Really. You have the ability to hire a lawyer, Mr. Humphrey. Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, you know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with police for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on. You were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 20,
Hold on.
yes, Judge. Yes, Judge. On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back two metal sheets that lead to two large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Say it again?
The complainant filed a civil lawsuit against the defendant for not paying rent, and that the complainant was there to obtain property. Or the defendant.
Mr. Gibson, I'm going to find that there's probable cause to go forward with your case. Your bond not to have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how the how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay. We'll take a
I
look
mean,
at
if you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time, you know?
Of course, Judge.
So,
Thank you.
but until that time, don't pick up a new case. Don't go back. All right. So Vic, you want to give me a date?
Yes, Judge. How is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work.
Yes.
Okay, jurors. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond condition. We'll have you sign it, and then you'll be free to go. Okay?
Thank you, Your Honor.
Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. Do you understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole.